Perfect. Well, welcome back, folks. Not everyone's quite back, but better to keep us as close to on schedule as possible. So after the lunch break, I'm pleased to introduce Katie Rothgary, who's from Brownstein. She is their Conflicts and Ethics Counsel, where she manages the conflicts intake group and offers counsel to members of the firm regarding ethics issues. She served as Assistant Regulation Counsel with the Colorado Supreme Court's Office of the Attorney Regulation Counsel. And she's going to pick up for us today something that Heather teased a bit this morning, and that's ethics in the electronic age, tips for staying online but out of trouble. Katie, I turn it to you.
Hi, everyone. Thanks for having me. I'm going to talk today mostly about social media and other electronic issues, I guess, that relate to lawyer ethics. So I'll be happy to answer questions as we go along. It's a pretty small group, so if you have questions, just shout them out. It'll be fun for everyone. So two issues in the world of sort of electronics and social media and blogging and websites that lawyers need to be aware of. One is our own personal use of social media and technology in terms of both our work and our personal lives and how we're using technology in our practices. And then also the use of social media and technology for purposes of your representation of clients. So how you're advising clients about their use of social media, or what kinds of issues might come up in matters that you're working on that relate to the client's use of social media. So we're going to cover both of those topics today. First, I always like to start with a little truth about social media. So how many people here have a presence on social media? And when I say social media, I am talking about Twitter, LinkedIn, Instagram, Facebook, websites, blogs, all of these things. This is, I think what we're really using social media for, even though we pretend like it's maybe like networking or some other more official use. If you haven't looked up your high school boyfriend on Facebook, you're probably going to want to get to that. Maybe during the presentation if you have Wi-Fi. But this is the basics. What is social media? Every once in a while I do this presentation and someone will really not totally be aware of what social media is or not really have an online presence, which I find sort of admirable at this point. Anyone who doesn't have any kind of online presence. But it's all of these things, some of which obviously are for generally more personal use. I think a lot of lawyers are on Instagram, but they're probably not using Instagram as part of their practice, whereas LinkedIn is a little bit more of the professional side of social media. A lot of lawyers are using that to network, to find clients, to find jobs, to sort of keep in touch with their professional network. So this is sort of the world of everything that we're going to talk about. And there are lots of rules of professional conduct that are implicated by our use of social media. So first, there's a relatively new comment to Rule 1.1 in Colorado that indicates that we all need to develop a certain level of competence when it comes to technology and social, and that includes social media. So we can't pretend like it doesn't exist. I had a lawyer in the fall who told me that he hates social media with the fire of 1,000 burning suns. And I like that image, and I get it. But even that guy can't pretend like it doesn't exist because, again, we all have to become competent enough to at least be able to talk to our clients about this or to even know what we don't know, right? So Rule 1.1 is implicated here. Also, the advertising and solicitation rules, they apply, of course, even in cyberspace, to our websites, to blogs. There are circumstances under which those rules could apply to what you might otherwise consider to be a personal Facebook page or a personal blog, and so we'll talk a little bit about that. The confidentiality rules clearly apply all the time, everywhere, and there are a couple cases now in Colorado of lawyers having violated this rule in an online forum, and we'll talk about those cases. the 3 series rules regarding how we interact with witnesses, opposing counsel, members of the public, judges, jurors, those are implicated again on social media. And with regard to technological advances, sometimes on websites, there's an opportunity for random members of the public to contact lawyers, right? Lots of websites have an, inquire here, contact us link. And there are several rules implicated by that kind of website or that kind of invitation to connect. And so lawyers need to be careful about when the attorney-client relationship forms and, being very careful about that. So that's another set of rules that apply. And then, of course, there's always the supervision piece for lawyers, supervising the people who work for us, paralegals and staff members and younger lawyers in the office, to make sure that their use of social media is consistent with the rules of professional conduct. So probably not surprisingly, there is no rule of professional conduct that says the words social media. But this is just like all the other areas in which the rules apply, in that the rules themselves don't change. They just apply in a new fact pattern. And social media is the sort of newest fact pattern in which we're going to start applying all the rules that have always been in place. So first, let's talk about lawyers' personal use of social media. The Supreme Court doesn't care about our personal lives all the time, but the court does care about our personal lives to the extent that things that happen in our personal lives reflect adversely on our fitness as lawyers. And so that's why the admissions office cares about stuff like, have you, bar applicant, ever filed bankruptcy? And if you've done it 12 times and you're 26, that's going to be a problem for you. And that same standard then continues to apply in some ways once lawyers are licensed in terms of, personal criminal conduct. Lawyers who get DUIs, those have to be reported, right? Even though it's outside of the practice of law, the court has some rules in place to cover these circumstances where the court feels like these are things that could happen that would reflect adversely on this person's fitness and whether this person should be a member of the bar. And so even in our personal use of social media, sometimes the rules of professional conduct are going to apply. There was a case out of Illinois. It's several years old now, but an Illinois lawyer maintained a blog. It was a mix of personal and professional talk in that she blogged both about sort of random musings and like the blind dates she went on, and then also about her work as a public defender. And the blog was not password protected. It was completely open to the public. And she blogged about specific client matters. And in her blog posts, she would identify the clients either using their first name, last initial, or using their jail ID number, which is particularly not confidential. And she would talk about those cases. She would talk about, things like, in court yesterday with number 65712, she lied to the judge when he asked if she was still using meth. I can't believe what a dummy she is. Or, Tom J refuses to take the great deal they're offering him. He's totally guilty, so she definitely take the deal. Lots and lots of information that would otherwise be confidential. And she wasn't a new lawyer. She was like a 15-year lawyer at the time that all of this went on. So this isn't a problem unique to the millennials. It's, her blog evidences, I think, a little bit more of someone who's maybe gone over the edge and is like burnt out. She probably, instead of blogging, maybe should have taken a sabbatical, which, she ended up getting because she got suspended for 60 days. So that's probably just what she needed to rejuvenate. But that was a 1.6 problem, too much information about the clients. And even though it was her personal blog and that she didn't maintain it on her law firm website or on the public defender's website, or she didn't use it to advertise her services as a lawyer, still she's talking about cases and talking about clients. And so she's still subjecting herself to the rules under those circumstances. Another couple of cases in which lawyers have gotten themselves into trouble, an attorney in Florida was publicly reprimanded for making derogatory comments about a judge. This case is interesting because the judge about which this lawyer was commenting was in fact grieved and disciplined by the Judicial Commission in Florida. So his comments, his comment specifically was that she was an evil, unfair witch. I don't think she was disciplined for being an actual witch, but she might have been unfair. I think she maybe was disciplined for being unfair because the Judicial Discipline Commission did find out and did find that she was biased and that she had treated defendants unfairly in their appearances before her. So he wasn't, maybe wasn't wrong in commenting negatively about her, but the Florida Supreme Court found that his comments were inappropriate and were a violation of the rules of professional conduct. Now, interestingly, Conway stipulated to a public reprimand. When that stipulation was reviewed by the Supreme Court requested briefing on the First Amendment implications of the case. So that was briefed. Then the Florida Supreme Court affirmed and accepted the stipulation to public without an opinion. So obviously they were thinking about the First Amendment issues because they requested briefing, but they didn't end up ruling as to those issues. There's an interesting question, I think an open question, about what would happen with this same kind of case in Colorado. The Colorado Supreme Court is historically protective of lawyers' First Amendment rights and generally applies the defamation standard to a lawyer's public comment, like Mr. Conway's. And so it's not clear, I don't think, that a Colorado lawyer would be disciplined in this way for this kind of commentary, but certainly the case is one to keep in mind and think about, not just in terms of the rules of professional conduct and the ethics issues, but also the professionalism component and sort of maybe how this lawyer wants to present himself in an online forum. There's a prosecutor in Texas. This is not a disciplinary case. It's just a case that was sort of in the news for a while. She requested a continuance from the court regarding a trial that she had pending. The court granted the continuance. The request was made because the lawyer said she was attending a funeral. And then during the week of the continuance, the week of the continued trial, that the trial was supposed to take place, the judge saw on Facebook the lawyer's posts, and the posts did not really indicate grieving. The posts were more like Margarita Monday and jet skiing with the girls on Tuesday. And, it just looked a little bit more like a vacation than a funeral. And the judge, in commenting on the case, was very judicial and saying, everyone grieves differently. So I don't know that she was not at a funeral. But the lawyer came back and asked for a second continuance. And I think that's when the judge that tipped the scales for the judge. The judge did end up reporting that lawyer to her supervisor in the district attorney's office. And obviously, that's just embarrassing, right? Now this lawyer has to appear in front of this judge. It's just not the place any of us want to be. So thinking about who your Facebook friends are is a really good idea. Lots of us have lawyer friends who then are elevated to the bench, and there's no rule that says you can't continue having a relationship with those people, but to the extent the relationship is occurring online through Facebook and your Facebook friends, there are maybe things to think about in that regard, right? So either this lawyer maybe forgot she was friends with this judge on Facebook, or maybe her page was totally public, which is not recommended. In any event, this is probably not the kind of thing you want the judges that you're appearing in front of or opposing counsel or clients to see online. And so this is just a good reminder to be careful about that. Did you have a question?
I was going to ask what business a judge has checking somebody's Facebook page out. Isn't the judge limited to the record that's presented during evidence?
That's a good question. So the question is, isn't the judge limited to the record that's presented in evidence? And I think that's true if there's a trial pending, obviously in front of the judge. So that's the piece that I don't know in terms of the story that was told. I don't know if they were Facebook friends. Just sometimes judges and lawyers are Facebook friends. So I don't know if this popped up in the judge's feed, right? As like, here's what your friends are doing, or if the judge went looking. That's not clear. So referencing back to the advertising rules again, there are a couple of new opinions about the advertising rules and when they will apply. These are from California and from the District of Columbia from last fall. They are close in terms of their holdings, but not exactly identical. So the California opinion says, blogs are not subject to the rules regarding advertising and solicitation unless the contents expressly or impliedly indicate the attorney's availability for employment. So if a lawyer has a Facebook page, for example, on which the lawyer both advertises his or her law practice and posts pictures of her cats, that page is probably going to be subject to the advertising rules and the rules about solicitation. Whereas if a lawyer keeps those pages separate, and has privacy settings that would keep the personal part personal and the professional part professional, then the personal side is probably not subject to the rules of professional conduct. So that seems like the way to go. I certainly would rather my personal life not be subject to the rules of professional conduct. And so it's a really good idea to keep those separate. So I know a couple of lawyers who have a Twitter page or a Twitter feed that they use for professional purposes, tweeting about the latest Supreme Court case or the latest rule or regulatory change that's happened. And the lawyers I know who do this then have a separate personal page, right? So they have a Twitter feed where they tweet about like Jayhawks basketball, and then another Twitter feed with a totally separate set of followers where they tweet about, here's what's happening in the world of ERISA right now. And that's one way to make sure that, again, these rules aren't going to apply in a space where you aren't really thinking of yourself in lawyer mode, you're thinking of yourself in personal mode. So the DC opinion is similar, although it's a little... I think it's, frankly, a little bit scarier because with the DC opinion is any social media presence, even a personal page, could be considered advertising or marketing. So it's a little more like we're going to look at this on a case-by-case basis and decide, once we've read your whole Twitter feed, whether we think it should be subject to the rules of professional conduct. So again, I still think even under the DC opinion that it's a good idea to keep them separate, and that would be a good argument. But it's a little bit of a distinction, and I think something to keep in mind as we see how the different jurisdictions are coming down on some of these issues. The DC opinion also, there were two opinions that came out on the same day in DC, 370 and 371. The other opinion also talks about positional conflicts and the idea that taking a position in a blog post or other public forum that is contrary to a position you're taking on behalf of a client could be evidence of a positional conflict, which I think is interesting, and I am anxious for someone to be the test case on that issue, because that's, I think, going to be a new area, and I haven't seen any opinions or cases that are addressing that specific issue of positional conflicts, but that's just a little sort of nugget to keep in mind in terms of what we're saying publicly that might be conflicting with what we're doing in our professional lives for clients. So as I mentioned, there are a couple of cases now from Colorado in which lawyers have been disciplined for online activities. So both of these lawyers were disciplined in 2016. The cases are factually pretty similar. So clients posted negative reviews. One set of reviews was on Google+. One set of reviews, I think, was on Yelp. Some of the reviews were on the Better Business Bureau website in the form of complaints. So the Better Business Bureau website posts complaints that they receive, and then there's an opportunity in all of those different forums for lawyers to post responses, or the business owner to post a response, in this case, the lawyer. So these two lawyers both responded. Their responses both went way too far in terms of disclosing confidential information about clients. So Mr. Isaac was reviewed by two clients in response to both of the posts, which were negative reviews from clients, because, as I'm sure you know, people rarely submit positive reviews, even about restaurants. They're always negative. So both the reviews are negative. In response to the reviews, Mr. Isaac posts lots of details like, this client XYZ was charged with 5 felonies, and lists out the felonies, and then paid me with an insufficient funds check that it took a month for me to resolve. She lied about all these different things, lots of detail, things that he only knew because of the representation, right? So confidential information under 1.6. Mr. Underhill similarly responded to his client's negative reviews saying things like, I should have known that a guy who skipped out on his child support payments for 5 years would stiff me on my bill at the end of the case. So that, that's not good. I don't recommend that. So both of these lawyers were suspended. They got significant suspensions. There was lots of other misconduct. In Mr. Underhill's case, Mr. Isaac had a significant disciplinary history. So I don't know that simply the online responses result in, this kind of sanctions they received, long-term suspensions requiring reinstatement. But certainly it's something the court's concerned about. There was a lot of talk in the Office of Attorney Regulation Counsel about the unsettled question of how a lawyer can or should respond to an online review. So I think especially in the world of solo practitioners and small firm practitioners, online reviews matter a lot. What someone sees when they Google your name, if the first thing is like this negative Google Plus review that pops up, that's really going to have a negative impact, especially on a small business. So I think there is a lot of discussion happening about how a lawyer could respond or should respond, what would be allowed under the rules. And I think that these lawyers didn't make it hard for the court. They didn't make it hard for the hearing board or the presiding disciplinary judge to find that they had gone too far and that their responses were inappropriate. I think it would be helpful to have what we don't have, which is an opinion about a more restrained response. If the response was more like not disclosing as much confidential information, or even, I think, an acceptable response under the rules would be to not even acknowledge the attorney-client representation that the client has raised, but to just say something like, here at the law office of Katie Rothgary, we work hard for our clients every day. We regret that we don't always get the clients the results they want, but we work hard for all of our clients, and we will work hard for you if you hire us. Right? Something like that. Something that's written sort of in the positive, and that doesn't even really address the representation, I think is okay under 1.6. I don't think that that's an issue. I can't see an avenue where there could be a complaint about disclosing information under those circumstances. So I think that's the best we can do right now without some other kind of opinion or comment to the rule or rule change with regard to what's allowed. But it's an interesting issue, and certainly if in these cases, these lawyers went too far, so we are figuring out what the outer boundary is. We just don't know sort of on the other side what's going to be okay. There's a really interesting case out of the Ninth Circuit. So actually, Judge Kaczynski, who's the chief judge of the Ninth Circuit Court of Appeals, he was investigated for allegedly off-color humor that was accessible on his family's internet page. So the facts of this case are interesting. Judge Kaczynski and his family maintained in their home a server, and it was a way for all their home computers to be connected to the same central location. Then the children grow up and they go away, and now the family still wants to be connected, so they put the server online. And then it's a way they can still all connect. Judge Kaczynski maintains on the server folders, and he is a saver. So in the world of email, I think there may be two kinds of people. I am the first kind of people, which is a deleter. I delete. I don't like my inbox to be full. I don't like to have to scroll down in the inbox. If I have to scroll, I feel like there's too much. So I'm constantly like cleaning it up. I do not think everyone handles their emails this way, and I think there's another segment of the population that saves everything and that has to constantly back up their inbox because there are 6,000 emails, everything ever received from the beginning of time. Judge Kaczynski appears to fall into that latter group. So he saved everything, lots and lots of emails, including email forwards, lots of sort of like seemingly innocuous, not having to do with anything emails. And he saved them in a folder called Stuff. Organizational skills appear to be his strong point. So in the Stuff folder, there are email forwards, photos, lots of stuff. And Judge Kaczynski was part of I think it's a website or an online forum of some kind called Beneath the Robes, which sounds much more scandalous than it is. So it was an effort to sort of make judges seem like real people. We're humans too, and here's what we do. And so it would be like, Judge so-and-so likes to go skydiving, and he's jumped out of 10 airplanes, right? Or, things like that. So Judge Kaczynski posts a picture, I think it might have been of him skydiving, onto this forum. That forum uses Yahoo Docs or some form of Yahoo that backdoored into the server and indexed all of the contents of the Stuff folder. Then someone commented on the picture that he had posted, but the picture they commented on was not the picture he posted. So this person saw a different picture, something else from the Stuff folder. And at that moment, Judge Kaczynski knew, there was something amiss, right? I didn't post that picture. I posted this picture. How did you see that one? What's happening? So they took the server offline and kind of thought that they had addressed the issues, put it back online. They had not addressed the issues, so the information was still sort of publicly accessible through a website link. I mean, you could go to alexkaczynski.com and see the contents of the Stuff folder, even though it wasn't a website he was purposely maintaining. So the judge is presiding over a trial. It's an obscenity trial, conveniently, and a headline hits the LA Times: Chief Judge of the Ninth Circuit maintains a porn website. So he recused himself from the case. He, sort of stopped everything, reported himself, sort of said, you should investigate me. He was investigated. The investigation showed that he was not, in fact, maintaining a porn website. There was some arguably off-color humor in the email forwards of the Stuff folder. So things like someone forwarded a link to a YouTube video of a man who was urinating in the field on the side of a road, and a donkey came and chased him. So kind of nothing, kind of like, what, first of all, why would you save that? But not porn, nothing sort of like as terrible as the headline made it sound. But he was still admonished, and the reason he was admonished is because he knew at the time, way back when, that the person commented on the wrong photo, that he had an issue, that there was more available online than he thought, that there was a problem with the family server, and he didn't adequately address it. And the court, or the Judicial Council, found that resulted in an embarrassment to the judiciary. So I think I like to talk about that case, even though, frankly, I do not really understand some of those technical pieces of it. And the reason I like to talk about it is because I don't understand those things, because it reminds me that Judge Kozinski and his family clearly had some level of expertise in the world of information technology. The ability to maintain your own server, it indicates a higher level of knowledge about information technology than I possess, and that I think many lawyers possess. And if he's, even with that education and understanding, still got admonished for this, it makes me think we all need to be really careful about what we post online. When you post something online, you lose control of it to some extent. So the email that you sent or the blog post that you created can be modified and forwarded and sent around to people that you didn't originally send it to. And that's where I think the problems can occur. That's where most of the problems do occur. And so I just like to talk about this case. I think it's just an interesting piece to address. So there are several ethics opinions indicating that we need to be really cautious about who we friend on social media sites. This goes back to the issue of judges and lawyers being Facebook friends. A North Carolina judge was publicly reprimanded for communicating on Facebook with a lawyer who was in trial in front of that judge during the trial about the trial. So that seems sort of obvious, but there maybe is something about the online nature of the forum that makes people forget all the rules they know, right? Like these people wouldn't talk about that in the hallway of the courthouse, but somehow Facebook made it seem like it was okay. I don't know, but we need to be careful about being friends on Facebook with judges. If you are a judge, with members of law enforcement, Facebook makes everything public in a way that can be a little bit scary. And so there are several ethics opinions now that are addressing this. The second piece of social media that we need to talk about is the use of social media in a lawyer's work. So lawyer competence in the electronic age. In 2016, the Supreme Court adopted this new comment addressing competence with regard to technology. It's comment 8 to Rule 1.1. And what it basically requires is that we all have some level of competence as to changes in technology so that we can advise our clients about these issues. Lucky for all of us, under 1.1, we're not charged with being competent in every area of law all the time, right? We get to have an expertise. What we don't get to do under this comment is pretend like Facebook doesn't exist and we just won't address it. So this has to sort of become part of the conversation that we have with the clients when the clients come in about what's your social media presence? What does that look like? Is there anything that we should talk about that could affect this case or affect how we're going to proceed in this matter? These are things that could make a difference. And so having that knowledge is really important. Lawyers are using social media now to sometimes investigate cases. Clients are using social media maybe to investigate, the person on the other side of the deal, or the person that's about to be deposed, or the other players that are involved in whatever legal transaction is happening. So the ethics opinions are pretty unanimous across the country so far in holding that information that's public is accessible and usable by a lawyer. So if someone has a completely public Facebook page, you can and should use relevant information that you find on that page. The trickier question is if there are privacy settings on someone's Facebook page. What you can't do is use surreptitious means to gain access to information that would otherwise be private. So you can't friend request someone without telling that person who you are and why you want to be their friend. As in, like when I was working at the Office of Attorney Regulation Counsel. I'm Katie Rothgary, and I'm investigating lawyer John Smith in this ethics case, and you are Facebook friends with John Smith, and I think you might have information that would be relevant to my investigation, so will you be my Facebook friend? Right? That's what it has to look like, an explanation of who you are and what you want and why you want it. You also can't have someone else do what you can't do online. And in general, under all of the rules of professional conduct, right? We can't have other people doing what we're not allowed to do. So you can't have a paralegal submit that Facebook friend request anonymously to gain access to information that you wouldn't otherwise have. So if it's public, it's usable. If it's private, then you can't get it unless you're upfront about, what you want and why you want it. The Colorado opinion that is probably the most recent of the various ethics opinions that have come out is consistent with the other states in this regard, in that you can use public information, but you can't use information that's private unless you explain yourself. Also remember that the rules about contacting people represented by lawyers apply online. So if you know someone's represented with regard to the matter you're working on, you can't call them on the phone, and you also can't talk to them on Facebook, right? Same rule applying in different settings. So that's just something to keep in mind. Investigating a potential client's or a client's social networking sites is a good idea, mostly so that you can decide, one, whether you want to take the case, and two, if you are going to take the case, what's on there that could affect what you're doing, or what's on there that the other side is going to ask for that you're going to want to know about before you produce it. So there's a couple of principles at play here. One is, of course, that nothing online is ever really deleted. So I don't know if you all are familiar with the Wayback Machine. Has anyone used the Wayback Machine? The Internet Archive. So you can go on this website, you can type in a web address, and you can see that web page as it existed on various dates. So you can go back to Brownstein's website in 2011, look at everyone's, bios. It's not every day, but it's, the website has sort of pinpointed different days, like Google caches pages at different moments. So sometimes this can be a really useful tool, because even though the website changes, or even though pictures get deleted or things get added, there is a record somewhere in cyberspace. I don't know where it all is, but it's somewhere. It's in the cloud somewhere. And so this is a good thing to remind clients about, that this is a good thing for us all to be aware of. This stuff doesn't really go away. So in advising clients, it's a good idea to think about things like, how many Facebook friends do you have? Because that will play into whether the client has an expectation of privacy on Facebook. If you have a Facebook page and you have 2 friends and they're your own children, and you only have Facebook so you can look at their Facebook pages, make sure they aren't doing bad stuff on Facebook, you might have an expectation of privacy as to your Facebook account. If someone else has a Facebook page and they have 600 Facebook friends, that is not private. Like, things you share with 600 people online, most of whom you don't actually know in life, are not private, right? And so the client needs to know you're not going to have an expectation of privacy about this. So, for example, while I'm handling your divorce, maybe no Facebook posting, right? You can say that. What you can't say, and what you need to be careful about, is spoliation. So this is where competence comes into play in a specific way. Understanding how the technology platform works, and what privacy settings are available, and what happens if you deactivate your account versus delete your account versus make private your account, could be really important to the client matter. So this lawyer in Virginia was suspended for 5 years. He was representing a plaintiff in a wrongful death case. The plaintiff's wife had been killed in a car accident. The other side made a discovery request for the client's Facebook page. Upon review of the Facebook page, everyone noted that the client had posted many pictures of himself on a boat, like drinking beers, surrounded by women, wearing a shirt that said, "I heart hot moms." And I think that this plaintiff's lawyer rightfully thought that that was not the kind of evidence that would convince the jury to award him a lot of money in his wife's wrongful death case. And so the lawyer said, we need to clean up the Facebook page. Clean up the Facebook page is not a technical term. So the client deleted the photos. But as I said, nothing's ever deleted, so of course they were recovered, and the other side found them. And then the other side filed a motion related to spoliation and won. And the lawyer and the client were hit jointly with more than $700,000 in fees related to the motions practice on the spoliation issues. So I think when I talk about this case, I like to give the lawyer the benefit of the doubt. I'm not sure that he understood what he meant when he said clean it up, or how the client would understand that, right? But that's why the competence piece is really important. Telling the client to delete photos online is just like when Arthur Anderson suggested maybe we could shred some stuff around here, you know? It's just like burning the, finaals from 10 years ago. So there's gonna be problems with that. There's gonna be spoliation issues. There's gonna be, violations of the rules of professional conduct. Suggesting that the client deactivate the account or make it private maybe is okay. Finding a way to preserve the Facebook account in its native format and then deactivate it is maybe okay. But that's where some technical knowledge of how the website works is going to be important. And so I like to tell people, if you're a person who likes social media, if you do not hate it with the fire of about 1,000 burning suns, and you're good at it and you feel comfortable with it, this is an area where you could develop expertise that would make you invaluable, either to the other lawyers you work with or to clients. Because a lawyer who has some competence in this area is important, and it could matter a lot. So at the end here, just a couple of additional resources if you're interested in more on this topic and the issue of social media, how to preserve it, how to advise clients about it. There's a few pieces. Remember, the same rules apply to support staff. So we have an obligation to make sure that the people who work for us conduct themselves in a way that complies with the rules of professional conduct, just the way we make sure our conduct complies with the rules. So just keep that in mind. That includes blog posts or website activity that maybe a paralegal in the office is responsible for. I'm happy to take questions, or if there aren't any questions, that's okay too. Go clean up your Facebook pages.
Thank you, Katie. Just because there weren't any questions doesn't mean it wasn't great. It was all right. Just scary.
I have a question. How do you find time to even look at Facebook?
How do you find time to look at Facebook? That's a good question.
Kind of a waste of time.
I feel like maybe there's someone out here maybe who was looking at Facebook while I was talking, because it wasn't all that thrilling, but that's a good question.
Those mobile apps.
Yeah, exactly.
Do you ever run LinkedIn?
Yeah.
You get these notifications that people want to be your friend on a LinkedIn, and they may be on the other side of a deal or
Yeah.
opposing counsel, or
Yeah, I decline a lot of LinkedIn invitations. LinkedIn has a setting where you can allow it to mine your contacts, and if you do that, it will send connect requests to everyone who is a contact in your Outlook address book. So I used to get them a lot from respondents that I was investigating. And I always assumed those are accidental because someone has clicked the setting saying mine, go through my contacts and send out connection requests. So I have turned that setting off. I think it's a good idea to turn that setting off. You also have to be careful on LinkedIn with regard to things that people might endorse you for. So there are a couple of ethics opinions now indicating that because it's your LinkedIn page, you have to control what's on it. So if someone has endorsed you for something in which you don't actually have experience or expertise, you need to delete that endorsement or decline it, right? So if you're a real estate lawyer and someone endorsed you for oil and gas law, you need to not have that on your page. Yeah, so LinkedIn has some settings that are a little scary like that, but if I think it's, if it's someone on the other side of a deal, I sort of generally assume they didn't mean to send me that, and so I just pretend like that never happened.
That's why you've never responded to mine.
This is why I have no Facebook friends.
That's a-
Don't look me up. I don't have any friends.
Fair enough. Before we jump into the next, I told Sarah I would let everyone know that up at the front here, she put some pins, chapsticks, some other things that folks might like. It's all the Colorado Lawyer Assistance Program branded materials. So if anybody would like any of that, it's up at the front.